and welcome to you all. Thanks very much for spending a little time with us. I'm going to try to cover a lot of ground here and address the APRAIS, the Arizona Intimate Partner Risk Assessment Instrument System. Basically, that's what the APRAIS stands for. And this is something that's come in Arizona recently, has a lot of practical implications. So I'm going to talk research, and I'm also going to talk practice. We spend a lot of time at the Family Violence Center in the field observing cases, working with practitioners too. So I'll try and make it as relevant as possible. So I want to start by talking briefly about the concept of risk. And it's a very fancy word these days. We use it a lot. We talk about, things like risk of, prostate cancer, risk of heart attack, cholesterol levels, this and that. And we live in these risk societies, but in the field of domestic violence, we need to specify very clearly what we're talking about. And we often don't do that. So we need to start with risk of what? Are we talking about the risk of homicide or near death or injury, severe assault, maybe just re-assault, maybe minor assault? But we need to specify that. It's called an outcome measure. And without knowing that, we're selling ourselves short. We also need to talk about risk to whom. And usually, most of the research, in fact, has been done on female victims in heterosexual relationships. But are we talking about female victims? Are we talking about male victims, children, agency personnel? Again, it's important to specify. Another key issue is risk for how long. Systems aren't able to sustain, for example, protections and support endlessly. What does the research tell us about the duration of risk? When people are most vulnerable? And how do we allocate resources based on that sense of timing and vulnerability? And also, which responders are these risk assessments most relevant for? So I'm going to try and address some of these issues. The idea often afloat is that there are lethality assessments out there. And I want to start by stating the obvious, that assessing lethality is incredibly difficult because there are so few deaths, intimate partner homicides. So we usually use the language of risk assessment. We prefer it, even although the Arizona statute uses the language of risk assessment and or lethality assessment. So the chances of assessing deaths are remote and very, very low indeed. And let me just illustrate this a little bit more. The CDC data, on average, tells us there are roughly 15 million physical, sexual violence and stalking episodes, assaults, every year. Of those, there are 1,000 to 1,500 intimate partner homicides. And that depends on how you count. There may be more one year, less another year, so we can't predict. The higher the base rates, the easier it is to predict. In other words, the more frequently something happens, the better chances we have of predicting it. So if you're a defense attorney or a prosecutor, you need to bear these things in mind. Now, we know from our work in many fields that there are different kinds of risk assessments. So someone might think that they're an expert in the field of domestic violence, and they may make clinical judgments based on conversations with people. And these are professional opinions, and I know many people who are far better versed than I am in this in terms of sitting, listening, talking with people, and saying, oh my gosh, that's a difficult case, or that's a dangerous case. The studies on clinical assessments are really clear. Our clinical judgments are not good. Our actuarial judgments based on large data sets where we integrate statistical markers as best we can is much better. But that doesn't mean to say that we want to forego clinical judgment, because those feelings that we have, we ought trust at some level. So if we can combine the two, clinical and actuarial, then we're really getting somewhere. And this is what we've done with the APRAIS, and this is what most risk assessments in the field of domestic violence do. And that is called, when you combine the two, it's called structural professional judgment. Uses both, sometimes called structured decision-making. And the evidence here is really important. We use evidence-based frameworks, even although we know the evidence in these cases is tricky to interpret. But we want consistency, but we also want flexibility, hence the blending of those two. So we want to create within systems, within the state of Arizona, but perhaps nationally, shared language of risk so that we're all on the same page in terms of what we're talking about. And ideally, that shared language does reflect the state of the research. There's always a lag of a year or two or three, but trying to weave in the latest research is really important. And we want that shared language of risk to inform decision-making at many different levels. So for our purposes today, we may be talking specifically, for example, about criminal justice system decisions regarding bail, conditions of release or supervision or sanctions or treatment or something like that. We're talking less, the APRAIS wasn't designed to necessarily inform charging decisions, although sometimes it does. Obviously, that shared language of risk is related to public education and awareness. And this may include awareness amongst folks who offer legal services, social services, and other provisions for victims of violence. Now, asking open-ended questions where victims or others can elaborate gives us a great amount of information. But it's difficult to compare bodies of responses to open-ended questions because they're highly idiosyncratic. It's more difficult to standardize across those coded types. So this information may be potentially useful for, say, judges or prosecutors, but for researchers, that can be very difficult at the same time as it can be very enlightening, give us new leads. So one of the encouraging things in the risk industry, if I can put it like that, is that there's a pretty close correspondence between the research on risk in intimate partner violence and the findings internationally of domestic violence fatality review teams. So the research in both those areas really tells us that clusters of markers seem to matter, especially before the homicides. And that piece of information is important. So the clustering question is really about putting clusters of markers together. And practically the question is, how many markers can the system bear? If you're in a hospital emergency room, you may only have 20 or 30 seconds to accommodate a question on intimate partner violence, and that may be only one or at the most 2 questions. If you talk to emergency room docs, they'll tell you maybe 1 or 2. Now in the field, we pose these questions: what will the system in Arizona bear? And I'll come to that a little bit later. But this was informed very much by people in the field in Yavapai County, where we had a lot of work with systems, particularly patrol units, particularly judges, prosecutors, defense attorneys, and the county attorney's office in particular. So we had a lot of support with the victim agencies, victim advocacy services. So we blended that. So we looked at that clustering question around that. The best research out there from the fatality review teams, the deepest, comes from the Ontario Fatality Review Initiative, I think. And they were finding 10 years ago that 75% of their cases had 7 or more standardized risk markers. And I can point you towards these reports if you want that. Now, this was preliminary descriptive research without a control group. I should emphasize that. But it's still important as an observation. Why would we do risk assessment? Well, we want to connect victims and perpetrators with services to engage in things like safety planning. But we don't necessarily want to claim that safety planning services will keep victims safe unless we know for sure they do. So we want to be careful about this. We want to maintain evidence-informed, evidence-based practice. We know a lot about what happens before victims, female victims, are killed. Now, what are some of our challenges in this field? Well, the obvious one is if you do a risk assessment at one point in time, we know that risk changes. Anyone who works these cases knows full well, or talks with victims or perpetrators, indeed, these cases change. So the ideal is rolling risk assessments done over time. And this is what we've introduced with the APRAIS. We encourage people to do repeat assessments. The risk assessments tend to focus on criminal justice interventions, but we also know that criminal justice interventions for victims can themselves be problematic and risky. And there are other kinds of interventions too that victims benefit from that we might not consider in our risk assessment research. These might be the availability, for example, of affordable housing or childcare, jobs, job readiness programs, legal aid, things like this, which are all very, very important, which in an American welfare state that is less well developed, say, than the European models, we're always going to have problems with those provisions. Now, other challenges include these issues related to discoverability and notification of victims of the discoverability of the information that they might share. Does that disclosure, which is discoverable potentially, render victims more vulnerable? So we want to respect the dignity and autonomy of victims. We don't want to present an alarmist perspective, but we also want to be honest and clear and direct. So we don't want to say to people necessarily, wow, in cases like this, where these 7 red flags are waving around, you know, women die. That's an inaccurate statement to some degree. Some women may die, but a small number. So how do we finesse that? That was always a challenge in really the 10 years it took to develop the APRAIS tool and to refine it. So another way of saying that might be that these risk markers are present. Researchers have found these, but even when they're present, we find many, many, many cases, perhaps hundreds of thousands a year, where women are not even re-victimized, let alone killed. So how do we do that? Those are practical questions, and we've hired seasoned police officers on our team to help us do this. Can victims give informed consent under duress at a scene? Are we to assume that victims are giving consent when we propose these questions, these risk assessments? Or are we being, perhaps paternalistic in sensing that they can? Or are we being paternalistic if we sense that they can't? Are we thinking that they are maybe incompetent at some level to give consent? A lot of questions come up around this. So should they give informed consent? We also want to make sure that we adhere to the principles of fair justice and all the implications out there about the inappropriate denial of bail, for example, to certain groups within the population. So it's important for us to explore relative and absolute risks, and I'll address that in a little bit. Other objections to doing risk assessments or challenges sometimes are the time it takes. It's often a reason stated, it was in the early days in Arizona, for not administering or even considering risk assessments. Officers would tell us, the patrol officer units that we worked with in Prescott Valley, when we piloted this, they gave us rich feedback for a long time, and they told us, well, it's more dangerous for us to stand around the scene and take risk assessment information in. The longer we're there, the more vulnerable we are. And of course, we were very careful with this, but we didn't want to be confrontational, but we also wanted to say, how do you know that? And that's a key question that emerges in the literature all the time. How do we know what we know about these things? It may be that you may be more vulnerable in certain situations, but it may be in subsequent situations, in subsequent calls to the same residence, that your brother or sister officer may actually be safer, or you yourself may be safer if we take the risk information now. So again, complex issues. The field it's in is really in its infancy. What about resource follow-up? Is that available? If you start running these risk assessments through your system and you start identifying high or elevated risk victims, do you have the resources to cope with that flow of cases? Again, this requires a coordinated community response and a thoughtful intervention here with regard to risk. We can't just do this by putting a form into a paper trail within a police department or within a criminal justice system. It's much more complicated than that. So I want to talk now about perpetrator and victim behavior, relationship dynamics. And we have these sort of stereotypes within the field that get in the way sometimes. We often see the virtuous female victim and the one-dimensional male villain. This is a problematic binary. Anyone who talks with victims know, or anyone who knows human beings knows, that we're a mix of good and bad. And everybody is. So this binary in the field of domestic violence is no exception. We know we're going to see these binaries, but we know that they're going to be problematic. The APRAIS was designed to take some of this stuff into account. We know we'll encounter denial and minimization. We know that abusers will minimize what they have done, maybe. We know that we'll get denial on the part of victims sometimes as well. We know we're going to see what is tantamount to the appearance of dishonesty. We'll see witness intimidation. We'll sometimes see seeming complicity. Victims will seem to be complicit with abusers in their illegalities, even although it's not necessarily in their interests to be that way or appear to be that way. So what we see is a lot of seemingly counterintuitive behavior of victims. They won't necessarily report. They fear losing their kids. They have hope for the relationship. Maybe the relationship will be salvaged. Maybe they'll return to their good old days. There's a concern about divorce, the stigma attached to divorce, and of course, leaving and all the material elements of leaving is very, very difficult. Ensuring your safety, ensuring that you're confident to move forward with your life. These are very difficult things. Victims may appear indecisive about leaving. And there are many, many reasons for this. They're going to lose their home, possessions, job, father for the kids. A lot of reluctance. And this reluctance will feed into the willingness, perhaps, to complete a risk assessment and to put a formal paper trail within the system. Safety issues are really important. Leaving can be dangerous. So the payoffs often have to be delayed. And they're also going to deal with the remorse of the person who's beaten them, maybe begging for forgiveness, maybe promising to change. We also see other behaviors in these cases which make it really difficult for us. And I always get in trouble when I talk about some of these elements, which is why I like to talk about them. But batterers and victims are really complicated people. And we see taunting sometimes in these cases and potential provocation by victims. And I've talked with victims about this in live cases, and I've also talked with perpetrators about how they perceive that behavior. Is this victim blaming? It depends. She's not responsible for his violence, but these elements are important aspects of safety planning, and they're important aspects of assessing risk. Is the taunting, is the potential provocation, if we see it that way, inadvertent, or is it deliberate? How does that play out? What might that mean? Again, these are uncomfortable issues that we have to talk about. Now, I want to talk about offender behavior and distinguish between a couple of things here. There is something in the field, the researchers, Michael Johnson is one of them, refer to as situational couple violence, lower grade violence. Maybe if you shove someone and they fall over a rock or something and hit their head and kill themselves, the consequences can be severe, but usually the situational couple violence involves things like slapping, pushing, shoving, lower grade violence, usually less injuries, and not part of a campaign of trying to regulate someone, dominate someone, etc. We contrast that with something like intimate terrorism, sometimes called coercive control. The situational couple violence occurs a lot. It occurs often in younger people. It's immature behavior. People don't know how to communicate necessarily very well. And men and women engage in similar amounts of this. Many research studies show. But the intimate terrorism, from the latest research we have, appears to be profoundly gendered. Men do this much more than women. Men are engaged in coercive control much more than women, it seems, from the current research. The intimate partner homicide is not only connected with clusters of behavior, it's connected with the coercive control and the intimate terrorism. So what we had to bear in mind when we put the APRAIS together was we want to create a tool that captures in clear signal form in measurable items that are relatively quick to assess the nature of severe violence that smacks of coercive control and intimate terrorism. That's very difficult because intimate terrorism, coercive control are abstract concepts. And the signal questions that we're using with the APRAIS and that most risk assessments use is very precise, very targeted. So identifying the situational couple violence and the intimate terrorism is important in terms of assessing real danger. Now, I want to go a little bit further, and I want to just mention two different types of intimate terrorists, because this too impacts how we intervene in these cases. The majority of intimate terrorists, these are the severe domestic violence offenders, the repeat offenders, the ones that are particularly resistant to treatment. The majority of them are what we term dependent intimate terrorists. The others, which are fortunately less numerous, and probably, if I were to guess from my experience, about 20% of batterers are what we might call antisocial or personality disordered intimate terrorists. And these are more resistant to treatment, they're more difficult to deal with, they're more manipulative, they're less dependent, they're more calculating, they tend to be more psychopathic. Both are impulsive. Both 1 and 2 here on this slide are impulsive. They're both accepting of violence. They both tend to be hostile to women, and they tend to have very traditional sex role attitudes. They tend to have a certain type of entitlement vis-a-vis women, certain type of expectation vis-a-vis women. So understanding perpetrator behavior is also important in these cases. If you do a risk assessment in a case where it's a dependent intimate terrorist, then you may think differently than if you have an antisocial intimate terrorist. Survivors cannot discern threat level easily. In spite of the fact that we value information from victims and that we value their input tremendously and we ask them about their perceptions, it's not possible for them easily to discern the level of threat, even although they may readily be able to, interpret mood on his part. They can't assess threat necessarily any better than we can. So these elements of the cases, the types of perpetrators, make safety planning difficult, and they inform safety planning. We have to bear in mind that perpetrators also engage in what we might see as contradictory behavior, paradoxical behavior. Perpetrator shame matters a lot. And shame and humiliation, what I call humiliated fury, are clearly linked to violence, especially in the homicides. They also can be very secretive, and we're all secretive at some level. But in these cases, we see acute secrecy, especially linked to issues of violence and trying to reestablish control and power. They are also, particularly the antisocial personality disordered ones, extremely cunning and difficult and sometimes very clever. So victims cannot know the threat. Agency and stakeholder players can't necessarily know the threat either. It's very difficult to read. Again, this is one of the reasons we wanted to get these signal questions in place so that they can give us some hard evidence to help us make sense of this. So to quote one of the guys whose work I like a lot, James Garbarino, Listening to Killers, published in 2015, he says most male killers are best understood as untreated, traumatized children who inhabit and control the minds, hearts, and bodies of adult men. This would not apply in the same way in domestic violence cases necessarily to the antisocial intimate terrorists. Perpetrators themselves have serious trust issues. They have difficulties with intimacy. They have very high abandonment anxiety and rejection sensitivity. They're very sensitive to being rejected. They often have attachment problems in their early life, particularly with their mothers. They may not remember their experiences. They may often be amnesic sometimes, genuinely, sometimes faking or malingering. They can be hypervigilant. And they may sometimes at scenes exhibit signs of dissociation, even during interviews, after scenes. So you may get detached, distance affects, even during screening, which makes the screenings much more difficult. This stuff will be associated with past trauma and self-preservation for the batterer. Offenders may genuinely believe that they were morally entitled to react violently in their situations. In the extreme form, they may feel so threatened that they engage in preemptive strikes, which can include also the homicides. So what I want to do now is to go through and look at some of the characteristics of dangerous intimate partner violence cases, and just lay out some of them. And this will lead me into the APRAIS tool itself and why we designed the questions as we did. So the most significant signal marker for us is a prior history of violence. We know in the social sciences that prior behavior tends to predict future behavior, not predict it very well, but it does. We know this from our suicide studies. We know this from our drug addiction studies. We also know it from the study of intimate partner homicide. So this red flag is probably the strongest predictor of serious injury and death. And you can see here in research that I conducted in Florida, where I had very detailed access to files and homicide files, police reports, etc., and interviews, I found that 86% of 67 female victims experienced prior woman battering. In other words, this is a significant marker. The Ontario Death Review data, which I trust and like a lot, pegged it at around 79%. In other words, it's a rarer type of case that doesn't have a documented history of prior violence or a documentable history of prior violence. That doesn't mean to say there wasn't any there. It's just that we weren't able to document it using multiple methods. Previous weapons use is another one, especially firearms. Violent events between intimates that involve firearms are more likely to involve death. They're more likely to end in death for obvious reasons. It's a more lethal weapon. Now, Jackie Campbell's work on this is instructive, but we have to absorb it with caution. She says from her research, published in the American Journal of Public Health, 2003, that women who were threatened or assaulted with a gun or other weapon were 20 times more likely than controls to be killed. It's important to realize that this is a statement of relative odds ratios, and these are unadjusted odds ratios. In other words, they don't necessarily take into account other variables as completely as they might. But still, this is a very potent marker. If someone's using a gun in these cases, we need to pay very close attention to that. It's a high-risk case. But the absolute risk is the other side of the coin. How many women, for example, when threatened or assaulted with a gun, end up dead? Because of the low base rates, those numbers are relatively few. So to understand risk, we need to understand the relative and the absolute risks to put it in perspective. And you may say, well, what the hell, it's not important. It is important because it matters in terms of how we talk with victims, whether we're overly alarmist, whether we're not. We have to finesse that language to be respectful of victims' emotional condition at scenes and post-scene and during, say, crisis intake, at a shelter, or subsequent to that. So even access to guns, Jackie shows, increases the risk fivefold. Again, that's a relative risk statement. And again, those are unadjusted odds ratios. But to emphasize this point even more, the National Violence Against Women survey found that very few victims of non-fatal violence report their intimate partner threatened them or used a gun against them. So it's 0.7% women, 0.1% men. In other words, what I'm saying with this is that the gun stuff is serious. It doesn't happen very often, even although predictively, in terms of absolute risk, it leaves a little bit to be desired. In terms of its significance overall, it is very significant. We have to remember that 60% roughly of intimate partner homicides are affected with firearms. Much higher percentage, 90% for homicide-suicides. Let's look at strangulation, choking, smothering, suffocation, whatever. Again, if the relationship has reached the point where we are seeing strangulation, obviously that can have very serious effects. Jackie found a 10-fold increase compared with controls in the rate of murder of women who've been choked and strangled. Those are unadjusted odds ratios. It doesn't mean that every woman who gets strangled is next going to be killed. This is nonsense. Statistically, this is not correct. But if you take the population of cases of women who are strangled and you track the ones who are killed, they are 10 times more likely than the ones who aren't strangled to be killed. But in absolute terms, if you take the population of women who are strangled, how many of them end up dying? The number is very, very much smaller. But the Chicago Women's Health Study found basically a fourth of homicides of a woman by a man involved strangling or smothering. My colleague Jill Messing found in very perceptive research, I think, that one prior act of strangulation increases the odds of a severe reassault or near death in the future. More than one act almost doubles that risk, you can see from those numbers. So what this tells us, very helpful, is that the use of serial strangulation repeatedly in relationships as perhaps a control tactic or a form of intimidation does correlate more highly with death outcomes. So surveys of women in shelters also show that a large number of women in shelters, and we have to remember that these are usually the most acutely victimized women who go to shelter. 68% reported strangulation by an intimate partner. Of those strangled, 87% said that that was accompanied by a threat to kill. 70% of those who were strangled feared death during strangulation, and a quarter of those women reported that their men had done that before. Significant stuff. Forced sex, another one. Jackie found a 7.5-fold increase, significant. Alleged non-consensual sex, in other words, a statement in, for example, an affidavit in request of an order of protection, we found, of non-consensual sex, not forced sex, has so outraged husbands that we found killings in those cases. In fact, the Pemberton case in the UK, which was the landmark case for British Homicide Review, contained that element in the case notes. Prior attempts to kill, more predictive of future severe reassault or near death than actual threats to kill. And this is fairly obvious, again, Jill's research. Abuse during pregnancy. I don't want to read all this stuff out, but you can see the kinds of horrors that we see in these cases. And of course, the fetus in utero also experiences these abuses. Stalking, again, another issue. Increasingly difficult given our technological age and the fourth industrial revolution that we're living through. It's difficult and increasingly difficult to track this stuff, know what's going on. But again, correlations between this and attempted and actual femicides. And then we come to the psychological and emotional stuff, which is part of these relationships. The isolation, the degradation, exploitation, attempts to control. My colleague Evan Stark talks about how the level of control itself may be a better predictor of future sex assault and homicide than actually prior assaults. And that may be especially the case with older populations where a history of violence has preceded the establishment of some modicum of control. We see surveillance. Some people call these things tactics. That speaks to the issue of intent. I'm not sure how we know precisely about intent with these guys, but entrapment, hostage taking, all of this stuff is part of the relationship. And again, I'm not going to belabor this. We see anonymous acts, sabotaging communications, threats on answering machines, tampering with clothing, objects of meaning, vehicles, cutting telephone wires, gluing locks. All of these have taken from cases we've worked at the National Death Review Initiative, stealing money, credit cards, checkbooks, etc. And also just making women feel crazy, by exploiting their fears, playing on their fears. Some people like to call that gaslighting. Anyway, there are other subjective elements. Does the victim think that he's capable of killing her? Not that she necessarily knows any better than the actuarial assessments, but what does she think? Is there escalation occurring? Is that significant? Are there twists in the abuse? Has something happened? Is something different happening? Are we about to reveal, for example, abuse of the children, particularly sexual abuse in a civil case? These are things that alarm and disturb and potentially humiliate abusers, and they're dangerous. Pending separation. These guys have, as I said before, incredible anxiety about separation, even although they're full of this bullying bluster. So we want to know, what's the status of the relationship? The Ontario folks found about 80% of their cases, there was actual pending separation in the relationship. So it seems like the first few days, up to maybe 3 months or so, appear critical. But the first 3 months is where we see roughly half the homicides. But we still see cases of death after that. So vigilance is important. Obsessive possessiveness. Is he violently and constantly jealous? Now, we all have property rights probably in our partners to some degree. That may be enshrined in a marital agreement or whatever, but we're talking here about extreme willingness to back it up with violence and heavy, heavy intimidation. Depression and suicidal potential. If I had one question to ask in these cases, if I could, it would be this one. And this is just emerging more in the research. We're finding research just in the last few years on this. Big data sets out of England. The Institute of Criminology in Cambridge has been doing a lot of work on this. We've known for a long time that depression and suicidal potential has been there in the homicide suicides. We see a lot of it, a lot of depression, a lot of desperation. The Ontario studies of 77 cases found that 45 of them, the perpetrator was depressed, either by a lay assessment or a professional assessment. They found prior attempts to commit suicide in almost half of those cases. A key question, if you can ask it, is, has your partner ever threatened or tried to commit suicide? I want to know that when I'm interviewing. I want to know whether someone's been institutionalized for suicidality and depression. And I want to know if that's accompanied by psychotic breaks and acute rage. Those things matter. So these are things that go along with the APRAIS tool. And there's some research here, and this is some of the research I was referring to. Perpetrator passive aggressiveness and paranoia and depression are really important. Bridger's research published in 2017 out of the Cambridge Institute found 40% of male intimate partner homicide offenders were known by someone, but not often the police, and this is important, were known by someone as suffering suicidal ideation, self-harm, or attempted suicides. It's important for cops to be asking these questions, and attorneys and victim advocates to be asking questions about suicidality. Button's research in the same vein, the same school of criminology, found similar things, and I don't want to read that out, I'm short of time. Alcohol and drug use, again, similar. Alcohol is obviously a depressant if you use it enough. Drug abuse, these correlate with domestic violence, and they're present in the homicides too. Chronicity here, the research seems to suggest, is the key. If you're soaked in this stuff continually, it's going to affect you. Now, other aspects of this, if he's feeding her habit, if he's feeding her meth or heroin, fentanyl, then it's going to be very, very difficult for a risk intervention to have any effect, or any coordinated community response to have an effect in that case. But we need to know that stuff. Stepchildren in the home is another significant marker. Some of these guys, and I say guys, but I also mean the occasional female, they're more dangerous if they're in a home where the child is from a previous relationship. This is a marker for violence against women. It's not one of the leading markers, it's a secondary tier marker, but it's still important. That control that he seeks, that he really doesn't realize that often, but that control that he seeks is also a retroactive control. Those kids remind him that she has been with another lover at some point, and that is deeply threatening. So we're talking here about compromised masculinity and shame in a lot of these cases, particularly with the dependent, vulnerable batterers. We're talking about, so to just perceive these men as powerful and controlling is to miss the boat. Yes, of course, they have power in some respects, but they are also powerless and their control is ebbing, and they kill in those situations where their power and their control is ebbing, not when they have it. So violence is an indicator really of the lack of power rather than the presence of power in some ways. Now, I want to say this, I get into trouble for saying this, so I like to say it. But mental illness is a big deal in the violence literature. I just finished reading, I don't know, a few months ago, Richard Taylor's work. It's a great book. It's called The Mind of the Murderer. It's published in 2021. And he makes a point in there that about 0.5% of the population, the global population, live with a diagnosis of schizophrenia. But they account for 6 to 11% of homicides. There is a gross overrepresentation of paranoid schizophrenics in the homicide literature. If we see mental illness in these cases, we need to pay close attention to it. We need to know if someone is suffering from psychotic breaks with reality, hallucinations, delusional behavior. These are important issues, even although people suggest to us that the mentally ill are just like everybody else. It's not true. They are more likely to commit acts of violence. The degree to which they do it depends on the type of mental illness. But the mental illness stuff has been underplayed in the movement, the domestic violence movement. We need to return to it carefully and thoughtfully. So the APRAIS tool was designed also to be a trauma-informed risk assessment. And it's designed to take place or to be deployed within a CCR, within a coordinated community response, particularly in marginalized communities, because we're well aware of the higher arrest rates. We're well aware of the higher DV frequencies in those communities. In poorer communities, in minority communities, the rates of DV are higher. The stats are very clear. So we want to do the risk assessment in a way that is sensitive to these things, but that is deployed in a manner consistent with victim rights, rights to be informed, rights to be notified of discoverability, but also within the framework of the rule of law, fair justice, and due process for offenders. So this is a difficult tightrope to walk. But the methodologies that we use in the APRAIS, and we have two wonderful police officers who work with us, Mark Perkovich and Greg Gianjobe, who heads up Greg heads up the initiative in state and indeed now nationally. And they spend a lot more time. They're far more eloquent on this than I am, but we've designed methodologies to prepare police officers to interact humanely with victims. And victims may be intensely traumatized. They may be unwilling to speak to officers or even share details. The questions may trigger things for them. They may not react or behave in ways that are predictable or may appear reasonable. We should expect this stuff if we've experienced this kind of violence. So anticipating that, preparing for that, emotionally preparing for that is part of the task of doing a nuanced, philosophically grounded risk assessment that has its home in true, decent community policing and true, decent criminal justice responses to these cases. So we value the recognition of this counterintuitive behavior. The trauma comes in different forms. It comes at us from all different ways. So our interactions with victims at scene prioritize safety and choice, collaboration, trust building, empowering victims, but also being present. We also know that being present gets information, and we're often not present these days, especially with the way in which our technology mediates our human interactions. But making eye contact, being present is important. And also recognizing that memory and recall are going to be problematic and potentially inconsistent. Victims may say no to a risk question, and the officer may perceive that something else is going on. We encourage officers to dig a little deeper, to explore whether or not fear and terror are operating there. We want officers to pay attention to body language, eye contact, if victims are making side glances to see where he is, whether he's in earshot, whether he can hear or see what's going on with the officer. So if there are signs of trauma, if there are signs of what the officer might perceive to be an inaccurate reporting potentially, not through any malign intent of the victim, but through a product of the circumstances, then we've built in an officer discretion override box into the APRAIS with very specific language, which I'll get to in just a moment. So now let's talk about the Arizona developments. Arizona is the only state in the union that has a risk assessment that has been approved and recommended as validated by its Supreme Court. So we're way ahead of the curve here. And many of us worked on this, probably some of the people on this call too. So this came out, as I said earlier, of a Yavapai County risk assessment project funded by the governor's office. And we're most grateful to the governor's office and the Office on Violence Against Women for doing this. And of course, to all our colleagues, Sheila Polk, County Attorney in Yavapai County, but also Chief Judge David Mackey and others, the police chiefs at the time as well. So it took 3 years to build the APRAIS tool, and it was based on field observations, many small group interviews with patrol squads, many heated discussions. I mean, I'm giving you the gloss here. This was hard work. And hats off to the Yavapai community. They had a CCRT in those days with 83 members. These were lively discussions. We asked them, how many questions would this tool bear? How many can you ask, for example, as a patrol officer in the field? You may not ask 20 on Jackie's danger assessment, but what could you ask? What would you be willing to ask? So the dialogue is important. We'd laid the groundwork with setting up fatality review teams. We had some of that CCR work. We knew about what was going on in some of the homicides. And we knew too that system players needed a way of sharing common risk information. And a key question in the development of the APRAIS was, how do we get it before the court at the initial appearance of the accused? How do we do that? So the statutory considerations, and I have a whole separate presentation on that, but ARS 3967 B5 actually requires the judicial officer to take into account the results of a risk assessment or lethality assessment in a DV charge presented to the court. So that's in the statute. That came out of Pima County, your own county. I think back in 2015, 2016, if Judge Million's on the call, she can correct me later, but I think it was around then. There are other factors relevant, obviously, to release decisions under that same statutory provision. The views of the victim come into account. The APRAIS informs, obviously, at that level, the nature and circumstances of the offense. So it's not just B5, it's B1, it's B2, evidence that the accused poses a danger to others in the community. We have a question in there on threatening to harm other people that you care about. 9, whether the accused is using any substance, or if its possession is illegal or use is illegal. So we ask questions about that. So there's a lot of overlap here between the APRAIS. It was designed to look at these elements of the case. It was also designed not to tap into prior history of the offender with the criminal justice system, because we know that there are certain groups in the population that have disproportionate contact, that have been processed disproportionately. So we avoided that. And if there are county attorneys on the call, or attorneys, prosecutors who were once defense attorneys, then you know full well the significance of that kind of a stipulation and writing that in to try to avoid some of those transgressions in terms of the representation or the misrepresentation of various racial groups in these cases, in the processing of these cases, and the bail setting decisions. So there's a heavy focus on how we do the APRAIS. And we acknowledge quite openly that we cannot easily predict outcomes. And I'm going to talk about very specific predictive statistics in just a moment. But the APRAIS was designed to address the complexities of intimate partner violence, the emotional complexities, the differences between situational couple violence and intimate terrorism, and the need to triage. We need to triage these cases because there are so damn many of them. So we have to find a way to triage at some levels. This was our best attempt, at the moment at least, to do that. So the basic logic was that past behavior is the most promising, albeit imperfect, predictor of future behavior. And in this mix, we're balancing victim safety against the rights of the accused. And this logic of balancing those two things was a logic that came from two different sources. One, it came from the Supreme Court, excuse me, in Arizona. Two, it came from our own Family Violence Center at ASU commitment to the rule of law and due process. We know full well internationally that violence against women and the plight of women internationally is far, far less in nations and societies that have a rule of law. It isn't perfect. There are a lot of problems, including in the US and the UK and New Zealand, and we know all these things. But in the advanced democracies with a rule of law, there's a better chance of getting at this stuff. So this balancing act was absolutely critical to the development of the APRAIS, philosophically. So it provides information gathered by police from victims, and it takes it to the court at the initial appearance of the accused. And there was a change in the rule of criminal procedure in order to do that. It doesn't contribute information necessarily, it wasn't designed to do this, for information at trial or a sentencing phase. It wasn't designed to infuse into, for example, the family court arena. Although again, it could be infused into the civil arena if it was accompanied by evidence, photographs, hospital, x-rays or this or that. You could put that package together, but that wasn't the original intent. So it provides first responders and victims with more information. And we figure knowledge is some power. It potentially provides victims in acute cases with time and space and resources to maneuver, because the idea is to link victims in dangerous cases up with services which we hope provide additional protections and resources for victims. And we hope that that dovetails, in some cases, with bail decisions where bail is either set more seriously or even potentially denied in some cases. And I understand the implications of that statement with regard to the Sixth Amendment. So we know these are complicated issues. The APRAIS has two tiers to it. The first tier is the highest predictive tier in terms of the questions. And if police departments come on board, and there are about 80 that have in Arizona out of roughly 120 or so, 140 maybe, that could use the APRAIS. If they come on board and they write the APRAIS into policy, then they're required to ask those tier 1 questions at scene. Tier 2 is optional. What we found in Yavapai when we were piloting this was that quickly the officers soon learned that if you ask tier 1 and tier 2, and tier 2 has 11 questions, tier 1 has 7 questions, and we'll screenshot that in a moment, that you get, if you ask both tiers, you get a very, very comprehensive sense of the case and what's going on. So we're also doing this. It's optional, obviously, for the victim to participate in this. The victim is advised that it is optional, it doesn't affect anything, but we're concerned for safety. We would like to ask these questions. We advise victims of the discoverability. So we have statutory support, we have administrative mechanisms in place, and we have law enforcement readiness, advocacy readiness. And again, this is part of a CCR. That's really important. So on December 13th, 2017, Chief Justice Bales of the Arizona Supreme Court signed off on the changing of the rules of criminal procedure to add this APRAIS tool, which is known, as you know, in the system as the Form 4C. And that became effective April 2nd, 2018. So it's been operational now for something like three and a half years. And my colleague Jill Messing, who's firewalled off from me on this, is doing a longitudinal evaluation of the impact of the APRAIS. So we're continuing to track this. We create shared language. The idea is to contribute education. Here's the APRAIS, and I want to just talk through this for a little bit. And I hope that you can all read this. But these are questions asked on scene, and this is a sample one that we just pulled from a de-identified case. And we've scored it. You can see the yes, no boxes here. You can see that this is a high risk case, and I'll explain why in just a moment. But if victims answer 2 or 3 tier 1 questions, yes, then they are at elevated risk. If they answer 0 or 1 yes, they are at risk. We never want to say that there's no risk. The cops have been called. We don't want to give the impression that this is a no risk case. That's not the case. There is a report of a disturbance. So there is a risk potentially. 4 or more, you're at high risk. This one has 5, you can see. So the high risk box is checked. Now, this is tier 2, so that's tier 1. And you can see the questions in here. I should probably ponder that for a moment. We've got the increasing frequency, severity, the jealousy. The blacked-in words are the words that the officer poses. They don't have to read these questions verbatim. The last thing we want officers to be at the scene is robots. We want them to be human beings. We want them to be present and engaging. But the blacked-in words are really key words that we want to get the essence across in the questioning. The jealousy, capable of killing, even though it's not necessarily helpful, it's still indicative of the state of affairs in that relationship. The pregnancy issue, the weapons issue, has he ever tried to kill you? Suffocation, strangulation, choking questions, 7 and 7A. So we sum those, we add them. Now, we were asked during the development of the APRAIS, and we were asked by various folks, this was obviously put out to review in the community. APAC sponsored this through the system, and we put it out, I think it was about 6 months for the community and various agencies to respond to it. One person commented that what happens if you only ask yes? If you only answer yes, I'm sorry, to question 6 and none of the others, has he ever tried to kill you before? Surely you're at high risk, but you wouldn't score it as high risk, it would be at risk. And our response to this is that this is a statistical anomaly. We heard from police departments, well, that means we have to go back and resurrect this case potentially. And our response to that was, well, yes, you do. If someone's tried to kill someone, that is part of protecting and serving people to go and explore that. So these are some of the aspects of this that were important, but you can see the clustering, the design. These are the most predictive questions that we have. And the validation of this came from my colleague Jill Messing's research in Oklahoma with an NIJ study. And the period of time that she tracked this for was 7 months. She tracked victims at the point of giving the questions, and then 7 months later, she tracked outcomes. Tier 2, less predictive, but still very important, speaking to issues of control in relationships, access to guns, forced sex. We sometimes get comments from police officers that they don't feel comfortable asking question 10, and some of them will just leave it out. And I would suggest that the discomfort of the officer here is something that departments need to look at. This is an important question. It's obviously a very meaningful issue for victims, and this is something that we need to address. We've got the illegal drugs or the misuse of prescription drugs question, harm to other people, the separation issue. Did you end your relationship in the past 6 months? Or alternatively, does he know or sense you're planning on ending the relationship? You know, these are important matters because of the abandonment anxiety. Financial loss, threat to masculinity, the same with the unemployment question. The suicide question there, question 16. Threats to kill and abuse of pets. We've also put that in there as well. So that's the APRAIS, the tool, a very comprehensive analysis of some of the key, most of the key signal questions in the field. Those questions were developed out of Jacqueline Campbell's original research, and we should acknowledge the elegance of that research. Now, this piece of the APRAIS is important, and the language here is important. You can see here, yes to 2 or 3, as I've said before, is elevated risk. Yes to 4 or more is high risk. Elevated and high risk scores trigger law enforcement officers to offer follow-up responses, maybe connection with victim services, other support services, resource information, etc. Departments themselves decide on this policy. Some departments might want to just go with high risk for making that connection. This is a question of numbers and capacity, and individual departments making their own decisions as part of the separation of powers within the criminal justice system in our democracies. So these are issues that are important for communities to decide. When we train communities in Arizona, the language is different because we have this statutory provision that changed the rules of criminal procedure. But in other states, when we do this work, and Greg G. and Joby does this work in other states, the question is a little bit different. But you can see here, with this particular case, the victim was referred for follow-up based on responses to the tool. Now, this was something that actually took a long time for us to iron out. There were people who attempted, police officers, very well-meaning, were tempted to say, when they saw these red flags like this, they were tempted to write on their piece of paper at the bottom of this, scribble somewhere in the margin, you know, something like, and I'm exaggerating here, but oh my God, this is a death waiting to happen or something. Now, if you do that, in that case, that's one thing, we've got a high risk case. You do that in a case where the officer suspects that there's fear and terror because the victim has said no to every question. What you do is you present to the court a judgment call that is, my intuition says this is highly dangerous, but with an empirical score that doesn't back that up. So we wanted to avoid that. So the victim is referred based on responses to the tool. That's it. Or the victim is referred for follow-up based on the officer's professional judgment. That box can be checked. So there's the override function there, but we were very, very careful with this language. And there was a committee convened by the Arizona Supreme Court to deliberate around all of these issues. So these, for the lawyers here, particularly and the judges, are probably the 2 or 3 most important slides. So we've already talked about the classification system. This is what elevated risk means. And we inform victims. The language goes something like this. The behaviors you answered yes to have been present in very dangerous situations, or something like that. Some colloquial version, some vernacular statement that is like that. We don't want to overly alarm, but we want to communicate what's going on. Elevated risk, in terms of relative risk, it means this: 6 times more elevated risk of severe reassault or near lethal violence when compared to those with fewer than 2 risk markers. That's the comparison. That's what it means. That sounds pretty compelling. It's 6 times elevated risk. If you're a high risk, you're 10.5 times greater risk than a victim who has answered 0 or 1 yes. You're 10.5 times greater risk in the ensuing 7 months of experiencing severe reassault or near lethal violence. That sounds very alarming. But the other side of this, and again, the Supreme Court Committee decided that we had to put the absolute risk language in there as well to balance this, to comport with due process and the rule of law. So relative risk is on the left-hand side here as you're looking at this. Victim who answers 4 or more out of 7 has a 10.5 times greater chance than someone answering less than 2 of experiencing severe reassault within the next 7 months. But in terms of absolute risk, among the victims who answered 4 or more out of 7 yes, using the APRAIS, roughly only 15% of them will experience severe reassault or near lethal violence within 7 months. That's a very different way of stating it. If I'm a defense attorney, and we love the defense attorneys, they played a very important part in the construction of this tool. I think they're a bulwark of the system in many ways, defense attorneys. So it means that 85% of them didn't experience that near lethal violence within 7 months. If we change the outcome measure, we ratchet it down a notch, and I don't have time to explain the differences between near lethal and severe reassault, but if we ratchet it down a notch to severe reassault, if the outcome measure is severe reassault, then our ability to predict goes up to 23% within the ensuing 7 months. So you can see how the outcome measure here matters and the time measures. Now you may say, well, what the hell? If it's only 15% or 23%, my client, if you're a defense attorney, is in the 85% or the 77% that isn't going to reoffend in the 7 months. What are you going to do about that? We'd have a better chance of tossing a coin on this one. That's not true. That's not true. But the response to that for a prosecutor might be, well, that's 7 months. We don't have the research on 9. We don't have the research on 5 or 3 months. We have it at 7. So the time matters in our ability to predict. And this is a gray area, and this is why we need much more research on this. This field is in its infancy, as I said. So these are very important questions. But if we look at it a little differently, the APRAIS tool correctly classifies 95% of those women who experience near lethal violence within that 7 months. In other words, if you take all the people who experience near lethal violence and they've all done the APRAIS would correctly assess 95% of them. That's pretty damn good. So, it depends on how we shade this. But that 95% is much better than what I've heard some defense attorneys say, is that a coin toss would be better. It wouldn't. A coin toss would correctly classify 50% of cases. And if you're a defense attorney or you're a prosecutor and you want a full written explanation of that, email me at my email address, and I will send you the publication that speaks to these issues. So both statements are accurate. But if you hear the relative risk without hearing the absolute risk, we develop maybe an exaggerated sense of danger, of longer term risk. What are the fair justice implications of this? We're just beginning to think this stuff through. How do we balance defendant freedom against victim safety? How do we balance the fact that we have victims or alleged victims who have sometimes impaired memory, who sometimes because of trauma inconsistently report? How do we weigh that? And again, these are just questions, the practical questions in the field. The researcher in me says that we have to be very guarded and gather evidence, but we at the same time want to respect victims at seeing and temper this tendency to alarm and paralyze as well. So these are really, really tricky questions. So I know that I've run over my time, and Ray's giving me strange looks, and I can see the chat box has 42 questions in it, or 42 statements at least. So I want to wind it down. Clearly, risk assessment tools are not evidence. They may be accompanied by evidence, but courts obviously have to adhere to statute law, which is different. Risk assessments obviously should not be used as the sole basis for granting or denying protection orders or determining guilt or innocence for that matter. Research in this field is in its infancy, and we have to use great caution. I would say to attorneys on either side, use great caution with this. The complexities of these cases, these battering cases, are really warrant care and attention. We cannot take the literature as it stands at the moment as the final word on this, as correct or authoritative or as necessarily valid. It's just getting going. We've got another 20 years to go before we can even, well past my career, before we can even begin to say more confident things about some of this stuff. And I think I want to end it on that note